Hello and welcome to the latest podcast from the Fraud Research Group at Aston University in conjunction with Amicus Legal Consultants. And today we're really focusing on a topical issue. I think one could fairly say a hot issue. It's the new failure to prevent fraud offence, which comes into effect on the 1st of September. My name's Martin Polaine. I'm a barrister and arbitrator. I'm also one of the directors at Amicus Legal Consultants. And I'm very pleased to say I'm joined today by Dr. Rasha Kazem and by Dr. Lindsay Cass. Dr. Rasha Kazem is a senior lecturer in accounting at Aston University, and she also leads the fraud research group there. So it's a particular pleasure to have Rasha with us today. Dr. Lindsay Cass is Senior Research Fellow at the University of Hertfordshire. Lindsay's speciality is nutrition and exercise physiology, but Lindsay has a particular interest in food and nutrition compliance. And of course, the food industry will be one of those potentially very acutely affected by the new corporate offence. So hopefully, we'll have a lively discussion today and focus on a number of issues which we know are causing companies some genuine concern. So, first of all, what is the new offence? As we've indicated, it's a corporate offence, so only organisations, companies can be liable. It's an offence of strict liability. We'll go into that in a little bit more detail in due course, but it means, in effect, fault on the part of the company does not have to be proved, and it's an offence with wide-ranging implications. So, Rasha, at the very outset, let me turn to you and ask this: who will actually be caught by the new offence? We've said it's a corporate one, but who exactly will be in that legislative net, as it were?
Thanks, Martin. So the Act is designed to hold these large organizations accountable for fraud committed by their employees or associated persons, regardless of the specific industry or sector in which they operate. The criteria for large organizations then would include more than 250 employees, more than 36 million pounds in annual turnover, and more than 18 million pounds in total assets.
No, that's really helpful. And I said it was a strict liability offence, and what came to mind for me was the very similar failing to prevent bribery offence under the Bribery Act. Is this new offence really a natural follow-on from that? And can you perhaps explain to us how we've got where we are today in relation to this new offence?
Yeah, absolutely. So the Economic Crime and Corporate Transparency Act in 2023 introduces the offence of failure to prevent fraud. And this act was significantly informed by a Law Commission paper published in June 2022, which examined corporate criminal liability and was authored by the Law Commission of England and Wales, which is an independent statutory body responsible for reviewing and recommending reforms to the law. So the Law Commission aimed to assess how effectively current laws hold corporations accountable for serious crimes, particularly fraud. And the paper then identified gaps in existing legislation that made it difficult to prosecute organizations for crimes committed by individuals acting on their behalf. It highlighted the need for a clear legal framework that addresses the complexities of corporate structures and the nature of corporate responsibility. One of their key recommendations was the introduction of a new offence, specifically targeting the failure to prevent fraud. And this would then enable the prosecution of organizations that do not have adequate measures in place to prevent fraud by employees or associated persons. The recommendations from the Law Commission then directly contributed to the formulation of the Economic Crime and Corporate Transparency Act, which, as you rightly mentioned, Martin, incorporates the concept of corporate liability for fraud, providing a clear legal basis for holding organizations accountable. And I also would like to add that it really aims to foster a culture of compliance and ethical behavior within organizations by mandating reasonable fraud prevention procedures. So it encourages organizations to take more proactive steps to mitigate the risk of fraud, aligning with the Law Commission's vision of enhanced corporate governance within organizations.
Yes, because it does seem deliberately draconian. So you're really saying that, yes, the force of this new offence is really to be preemptive, to get organisations to very much proactively have their anti-fraud procedures in place.
Yes, that's correct.
Well, that's interesting. What then would need to be proved by the prosecution? Could you perhaps break down for us the elements of the offence?
Yeah, absolutely. So an organisation may be prosecuted if it lacks reasonable fraud prevention measures, regardless of whether senior management was aware of the fraud or not. And as I mentioned before, it applies on any large organisation fitting within the criteria I mentioned previously in any sector or industry. So let's talk about reasonable fraud prevention procedures. The Act has been very specific about the principles for fraud prevention, which includes top-level commitment, risk assessment, proportionate risk-based prevention procedure, due diligence, communication, including training, and finally, monitoring and review.
No, that's helpful. And I think I'm right in saying that the statutory defence that's available would involve an organisation having to show that those reasonable procedures, broken down with those various elements you've described, were actually in place.
Yes, that's correct. I have to add as well that many organizations must have this as part of their compliance with the UK Code of Corporate Governance and also the Bribery Act. So it's not like they will start establishing these procedures from scratch.
No, that's helpful. So there'll be some way along the curve in any event. Lindsay, it occurs to me that obviously from a food industry standpoint, there's a lot of potential issues there, a lot of potential concerns that food and nutrition companies might have. Is there anything that comes to your mind straight away?
Well, really listening to this, Martin, I think when you spoke, Rasha, about UK based, obviously a lot of the food companies are going to be global and international. I just wondered what would happen then if the company was based abroad and was selling in this country, where the liability would lie then.
Lindsay, that's a really good question. I think it's fair to say that the jurisdictional reach of this corporate offence is very broad. And Rasha, it's right, isn't it, that it's not confined to UK companies. Instead, it's any organisation with a UK nexus, as the guidance says. Rasha, when we talk about a UK nexus, following on from Lindsay's very apt question, what do we mean by that?
An organisation may be held liable under the offence irrespective of where it is incorporated, headquartered, or operating if the fraud has a UK nexus. This could include scenarios, for example, where the fraud is committed within the UK, or the fraud targets UK victims such as customers, investors, or public bodies, or the intended benefit of the fraud accrues to a UK-based entity or individual. This kind of mirrors the extraterritorial approach seen in the UK Bribery Act in 2010, under which foreign companies can be prosecuted if any part of the offence touches UK soil or interests. Let's now talk about some practical enforcement considerations. In practice, enforcement against non-UK companies will hinge on more than just legal jurisdiction. Authorities such as the Serious Fraud Office or Crown Prosecution Services will need to consider evidentiary challenges, particularly in gathering proof across borders. Also, international cooperation requirements, which may delay or complicate proceedings. Also, they need to consider like the prosecution aspects of it, including assessments of public interest, strategic priorities, and available resources, and diplomatic or legal complexity, especially where enforcement relies on cooperation from less aligned jurisdictions. Let's now delve into what constitutes a UK nexus. While this is not really defined in the legislation, a UK nexus is likely to include any of the following, including the victim of the fraud is in the UK, like a UK-based investor, customer, or public authority, or the fraud is designed to benefit a UK company, individual, or business operation, or the fraud conduct occurs in the UK, or the fraud effects are felt within the UK, even if orchestrated from abroad. These thresholds give UK enforcement bodies a broad platform to assert jurisdiction over international corporate actors. Let's talk about the implications of that for multinational companies. Organizations operate across borders, for example, should not underestimate the reach of the new offence. In particular, multinationals with UK clients, subsidiaries, or operations must ensure their anti-fraud procedures meet the UK standards of reasonable procedures. And also parent companies headquartered overseas are not exempt if their UK-linked activities give rise to fraud. Also, exposure includes criminal liability, reputational harm, and financial penalties. This may trigger greater global alignment of compliance frameworks, encouraging consistent fraud prevention standards across jurisdictions. And also, while enforcement under the new law is still in its early stages, the UK government has signalled a more assertive approach to corporate economic crime through the establishment of the offence as a strict liability crime, meaning no intent or knowledge is required for liability. Also, reforms to the identification doctrine, expanding the definition of a company's directing mind to include senior managers, and increasing reliance on deferred prosecution agreements as a resolution tool for corporate offenders. These developments really suggest that UK authorities are prepared to test the boundaries of jurisdiction, particularly in serious, complex, or high-profile fraud cases involving foreign firms. Let's now talk about compliance takeaways for foreign companies. In brief, any non-UK organisation with UK-facing business should take proactive steps to reduce their exposure to fraud. And some recommended actions can include mapping out fraud risk and operations linked to the UK, reviewing, strengthening, and documenting internal fraud prevention controls, developing and training staff on reasonable procedures that can serve as a defence under the Act. And in that podcast, we provided some ideas about training that hopefully will be useful for those multinationals. Also, it's very important for ensuring these measures are applied consistently, including overseas branches, subsidiaries, or third-party partners with UK exposure. So really, in summary, the failure to prevent fraud offence applies beyond UK borders. A foreign company can be held accountable if the fraud is sufficiently connected to the UK, even if committed from abroad. Legal permissibility is broad, but practical enforcement will depend on risk appetite, resources, and strategic priorities of UK regulators.
Yes, I think the issue would be, I suppose, an investigative resources one, wouldn't it? In the sense that the police or the SFO might decide that they weren't going to prioritise an offence where a corporate offence like this, where the company concerned is a non-UK one, but it's a little bit like the corporate offence, the failure to prevent offence under the Bribery Act, isn't it? That it's not confined to UK organisations, UK companies, as a matter of law, but as you've said, whether there's going to be an appetite to actually investigate and prosecute a foreign company will depend presumably on the particular priorities of the time and the resources that are available.
Yes, absolutely, and whether actually the fraud was associated, happened in the UK, was perpetrated by the UK branch, by an employee who's associated with that particular, subsidiary or branch or not. I would like to see how this is going to apply in practice. For example, if fraud happened in the headquarters outside the UK, how would the law applies? I can see the only way of doing that is through international collaboration, which is something that many fraud fighters recommend.
I'm just going to come in here because obviously I'm the lay person on this chat that we're having. So maybe for the listener, I put it into more everyday language. So I am selling something that I've bought from a foreign company, if I'm looking at it from a food point of view, and they've put labels on there and they've said it's pure, but actually they've bulked it out, for example. So Mr. Smith now is selling that product in good faith in England with a product that he believes is what it says, but actually somebody finds out that the product isn't what it says. Now, he's obviously selling that product for his own gain because he owns that particular shop. So he's selling that product. Would he be liable in any way, or would it go back to the actual company that's selling the adulterated food, for example?
Yeah, very interesting question, Lindsay. I think they would be liable as well because part of the reasonable procedures put in place is the due diligence, for example. And if they are dealing with suppliers in the UK or abroad, they should put in place procedures to ensure fraud is prevented, as long as the person is associated with the organization is going to be liable. So you could say like, well, them dealing with a particular external supplier in abroad or in the UK is their responsibility, and this individual or branch or organization would be related to them somehow, and therefore the act would apply.
Yes, and Lindsay, on your example, assuming that Mr. Smith actually was a company rather than a sole trader, because obviously this is a corporate offence, so an individual can't be prosecuted for it. Of course, yeah. The individual can be prosecuted for the underlying fraud offence, but not for that. I think perhaps the other thing to emphasise is this: this corporate offence is very much dependent on what the associated person does. In other words, the employee, the agent, the subsidiary, whoever it might be, an individual or a corporate can be an associated person. And if the associated person is providing those services for or on behalf of the company itself, then that's where the liability kicks in. One should say, though, that supplying to rather than for or on behalf of is not caught. So in other words, if you've got a supplier, pure supplier, who's supplying something, they won't become an associated person just by dint of being a supplier, because obviously they'll be providing services to rather than for or on behalf of. So that's the caveat there. And it's an interesting area, because obviously one of the concerns for companies is that the category of associated person can be very, very broad, particularly if you're a company that uses agents or intermediaries to help take forward your business, to help you sell your services, etc. So that's where things can become quite difficult for companies themselves. And the notion of associated person is again one that we see in the Bribery Act as well, isn't it, Rasha? So presumably it's something that's been passed down to this offence again from the Bribery Act.
Yeah, absolutely. Yeah, definitely. I still think like this is kind of a grey area, with regards to like overseas subsidiaries, particularly if overseas subsidiaries of a UK-based company commits fraud locally, but there's no UK business benefit, then I mean there could be arguments about whether it applies or not. So it's still like early stages, I would say. So maybe in the future we can discuss this further as well.
Yes, I mean there would be dependent on whether presumably the gain or loss accrues in the UK, or whether one of the acts comprising the underlying fraud offence is committed in the UK. I guess that's going to be the test, isn't it?
Yeah, absolutely. I think the key elements from the Act, as we see it, is whether the person committing the fraud is associated with the organisation, and whether the organisation benefited, whether in the short term or the long term. And then obviously whether the organization is a large organization and fits within the categories we mentioned before as well.
Yeah, no, that's helpful. While we're looking at associated person, one of the things I noted from the government guidance that's been issued is that a franchisee wouldn't ordinarily be in the position of an associated person. There wouldn't be that relationship with the franchisor. But I know that in academia, one has franchises, and it appears the position there may well be slightly different. I know, Lindsay, this is an issue that has caused you some both interest and concern. I wonder whether you can perhaps give us an overview of the position as far as academic franchises are concerned.
Well, within academia, we have two different types of franchises, really. We have the validation franchises, where a university with the degree awarding power can accredit the degree of a college that doesn't have that power. So in other words, they end up with the main university's degree because the underlying university can't do that. So the student will receive the degree from the main university. And then we have the delivery provider franchises, where a university or another degree awarding body subcontracts the delivery of its programme to a delivery provider, but it still retains control of the content and quality assurance. So two quite different situations. I think they're both quite equally used in the UK. Often you find that the first one, the validation franchise, is set up maybe abroad, where the university will accredit a degree in another country but runs it through their own. Whereas the delivery provider one, whoever's delivering it has to show all the work that's done and all the assessments that are being done to the main university, or in fact actually use theirs. So they're quite different ways of giving out degrees. So I suppose what you're saying, Martin, is that now those franchisees have got liability in a different way.
Potentially, yeah. It looks as if the academic franchise potentially will be in a different position to what one might call the ordinary franchise. You know, the franchise for the fast food restaurant or something like that, or the opticians, whatever it might be. So, no, Lindsay, thanks for that. That is an interesting one. It may be helpful, I think, to our listeners if we perhaps look at specific sectors. I mean, obviously, this offence in principle can apply across the board, but I think certainly in the UK, one would imagine that there are some sectors that are going to be more vulnerable than others. And I, again, was trying to put together a little list in my mind, and I'd welcome, Rasha and Lindsay, your views as well. But it seemed to me that the sort of sectors likely to be affected in particular would be financial services, property and real estate, the pharmaceutical industry. I suppose pharmaceutical and healthcare would perhaps be the best umbrella. Retail and e-commerce, and Lindsay, you've obviously mentioned the position where sales are occurring cross-border, no doubt, or online. Construction and procurement, I suppose that's a biggie as well. And as we've touched upon at this stage tangentially, the food and nutrition industry. I mean, those seem to me to be perhaps the main sectors of vulnerability. Rasha, I mean, would you agree with that? Is there anything else you'd add on that?
Yeah, absolutely. I agree, Martin. But I would like to add that, generally speaking, the offence applies to large organizations across all sectors and industry, but those operating in fraud-prone environments or with complex supply chains, financial flows, or third-party relationships face higher legal and reputational risk. Let's talk, for example, about the financial services. They are at risk because of the complex transactions and high-value deals, and also access to sensitive data. So you would expect like a wide range of fraud types committed there, like, for example, insider trading, mis-selling of products, false financial accounting, mortgage fraud, Ponzi schemes, which is the investment fraud. And of course, that would make them highly liable under the Act due to the potential for internal or third-party fraud benefiting the institution. And then if you looked at the construction infrastructure, They have long supply chains and subcontracting, somehow vague billing or vague billing opportunities as well, which would make them vulnerable to specific types of fraud like false invoicing, bid rigging, bribery, overstatements of the work done, which again puts them under greater liability under the Act. I have to say as well, like higher education is also at a greater risk due to overseas partnerships, student recruitment agents, and growing commercialization. So they would be facing things like admission fraud and fake qualifications and research funding fraud, and even ghost students or employees. So again, UK universities with franchised or international delivery models may also be exposed if fraud occurs and lead to financial or reputational benefits. I mean, the list goes on. I have to say, think about tech and telecoms, for example, retail and e-commerce. Almost every sector with large organizations fitting the categories we mentioned before would be liable under the Act.
It's interesting because, you know, like, I think for the ordinary person out there that's learning about this, someone that doesn't have a legal background, I think some of the things that people aren't going to realise, and one of the examples that I feel really highlights how much has changed is, for example, if you look at maybe a leisure industry, for example, or a company that has lots of outlets throughout the UK, so they meet the criteria for having enough staff and high enough turnover. And quite a few companies like that do, like, you know, at the weekend they have people that come in to sell goods. So I think of that from a sports supplement nutrition point of view, where they come in, maybe sell their protein supplements, but some of them sell things like sportswear, or they sell jewellery and random pieces like that. I think what's really changed there is, say somebody's selling something within that company, now it's not the individual person that's going to be liable for it. So if the company takes them on and thinks, oh, I'll make, you know, a couple of £100 over the weekend just renting out a table in the reception, actually, if the company's big enough and that person's doing something that falls within this Act, the company itself now, how I understand it, obviously correct me if I'm wrong, they'll be liable for the sake of £100 for, you know, somebody locally to come and sell bits and pieces. Where I think a lot of smaller companies, but that are big enough, do this type of thing just to please their customers. I think that's where the responsibility has really changed on this.
That's actually an interesting angle. I mean, yes, the individual who's committing the fraud obviously will be liable for the substantive fraud offence, but assuming they satisfy that element of providing the services for or on behalf of the other entity, then yes, that other entity, that organisation is potentially liable. And I think one of the things perhaps to emphasise, and I know Rasha touched on it at the beginning when she was looking at the elements of the offence, even if the associated person's primary motivation is to benefit themselves, if one of the, if you like, subsidiary benefits is to the company, the organisation, then the organisation will be liable. When we talk about a benefit to the organisation, it doesn't have to be the primary motive. So, you know, the person selling on a commission, for instance, and being fraudulent in doing so, yes, he or she is motivated by the commission they get, by the bonuses they get, but of course the company as well will profit. So that becomes their exposure and their liability. So the example you give is actually a good one, and one that should have the corporate world really sitting up and listening. Subject, of course, as Rasha was saying earlier, to the organisation itself being large enough to satisfy the criteria that brings it within the offence. So I think that is an interesting one. Lindsay, can I ask you this as well? We've talked about various sectors, and Rasha gave some really apt examples around, for instance, construction and procurement and financial services. What about the food and nutrition industry? What sort of frauds, what sort of typologies of frauds does one see in the food and nutrition industry?
Well, I think it's quite extensive, really. But I mean, there's mislabelling, especially nowadays, where the labelling regulations are so strict, and also they differ now so much from country to country. In fact, there are organisations now that just deal with advising companies on what labelling they need to put on their food if they're selling it in different countries. You've got substitution of one ingredient for a lesser quality ingredient. I think in a way less rare if it's a recognised company would be, padding out adulteration of the food and padding it out. I don't know if allergies so much come under a fraud because they're not a fraud, but I think when you look at them from the food labelling point of view, now the constraints around there, who would be liable?
But if the labelling's fraudulent, then of course it becomes an issue.
And you've got supply chain vulnerabilities as well. Especially now with our international markets and people being online, I think there's a lot of issues around supply chain and being able to, follow where your product is and what's happening to it.
So a fairly extensive array.
Yeah.
So I suppose having perhaps been very, very cautionary as far as the message we've got out to companies, we need perhaps to look at what companies can do. Rasha gave us this overview of the components that make up reasonable procedures. And I noted that in the guidance, number one in the list was top level commitment, presumably sort of senior management commitment. Rasha, what's the expectation on an organisation, on a company, or I should say specifically on a company's senior management? What will they be expected to do or to have done?
A lot of things, I have to say. Let's start by them upholding integrity, because this is what we call the tone at the top. It's very important for the top leaders to uphold integrity and to have this message that clearly communicates zero tolerance to fraud. Fraud is not really a type of risk that organizations should tolerate, unlike other types of risks, and therefore there has to be a clear message about the lack of tolerance for fraud and procedures and investment to ensure that there is proper procedures in place for preventing fraud. So it's important for top management to link fraud prevention to corporate governance obligations, and to ensure that fraud and economic crime risk are formally documented in their register. They have to think about appointing maybe compliance professionals, counter fraud professionals, internal auditors that could then help them to do continuous risk assessment. They have to communicate about fraud risk at the board level and also manage that risk. So it's not enough to assess the risk without managing it. This has to go hand in hand, fraud risk assessment and fraud risk management. They have to align fraud prevention really with the strategic themes like trust, reputation, compliance, and ESG, which is like a hot topic at the moment. And they talk about sustainability. Obviously, when we talk about fraud, there is no sustainability because fraud can compromise sustainability and the ability of the organizations to survive. We've seen so many examples of corporations falling as a result of fraud, like Patisserie Valerie, for example, Germany. So again, it's important for the top leaders to walk the talk, so upholding integrity themselves and then communicating fraud strategy, investing in fraud prevention techniques, and staff to carry out continuous risk assessment. Rewarding integrity is also one thing because it sends a clear message that the organization and the top leaders appreciates integrity within the organization, which then would encourage others to follow the same pursuit in that case. It would be nice to see like an appointment of a board level champion for fraud prevention, for example, maybe a CFO or a chief risk officer or any named trustee who would be dedicated mainly for fraud. I haven't really seen that in practice yet. And also there has to be clear definition of fraud related responsibilities in executive job descriptions, again, to reinforce how important that top level commitment to countering fraud is. Many examples really that we can talk about, but one of the things that they can do is having like a code of ethics that specifically mentions fraud and zero tolerance to fraud, as I mentioned, as well as the consequences of committing fraud. It's a balance between scaring people off, telling them more about the consequences, and also encouraging them, this is the positive reinforcement part, not to commit fraud. There has to be continuous training to explain to people the consequences of committing fraud, but also what would happen if you are upholding integrity, what would be the positive outcomes. at the individual level and also at the organization level. Obviously, no one likes to work for an organization that is going to collapse as a result of fraud, and it will happen eventually. So again, this has to be clearly communicated to employees and managers at all levels.
Yeah, so clearly an onerous responsibility on senior management. I suppose, picking up your point around having a champion, I suppose one of the key roles would be that of the non-executive director, as well as there being executive leadership. We know that good governance indicates an important role for the non-executive. I suppose here one would hope that the non-executive director would give some meaningful oversight as well.
Yeah, completely. I agree. However, I'd like to add to that that the champion should also be from the executive team, because they are going to be responsible for the day-to-day operations, while the non-executive directors are, clearly independent from the organization and providing this unbiased view to the, stakeholders, the shareholders mainly of the organization. So it would have both non-executive directors with counter-fraud expertise or interest, as well as an executive there to oversee fraud prevention across the organization.
No, that's helpful. Rashi, you mentioned risk assessment, and I think we clearly have to emphasize the importance of risk assessment. Obviously, the fashion, one can call it that, with procedures that are expected now across the anti-bribery, anti-fraud, indeed anti-money laundering framework is the notion of a risk-based approach, and then of course having proportionate procedures. And I must say, one of the things I've noticed when I've advised companies in relation to Bribery Act adequate procedures is that companies often have to be reminded that risk assessments must be very much specific and company-centric, not simply generic. I've lost count of the times I've seen companies with generic risk matrices that don't really encourage a frank appraisal of what the risk is and whether the risk can be minimized or mitigated. So I think one of the things I would emphasize is the importance of having sector and company-specific risk assessment and risk assessment tools, in other words, matrices. So I think that's a key point. You mentioned training, and obviously that's key, given that of course the training need will extend not just to members of staff of the organisation, but potentially to agents, intermediaries, other external stakeholders who are capable of amounting to associated persons. And I think that's got to be right. Lindsay, I know that obviously as an experienced educator, you have a particular interest in not just the fact of training, but how training is actually delivered, how it can be actually used to achieve a sustainable result and sustainable knowledge. What would you say around perhaps the best approach to training, the best methods that companies might use really to drive the message home?
I suppose they need to get the information out there. So I suppose initially it would be for the employees to read what the managers or the company themselves are putting out. But then I suppose the best thing to do is actually try and do some kind of stress testing where they actually maybe role play or put through some of their policies to make sure they work. And I suppose beyond that, they need to sort of monitor the effectiveness of it. I think that's something that happens is people do their training in the first place. I think particularly at universities, there's a lot of courses that everyone does at universities that, because it's so broad, we cover everything from health and safety to all the regulations that are out there. So I suppose really what you need to make sure is that it's still fit for purpose some months down the line. And I think that becomes a bigger issue because there's so many staff involved and people are so busy. You have to be able to regulate that people are actually doing the online or face-to-face training.
Yes, and I think that seems to me to be absolutely right. And you've drawn, I think, that connection between training and monitoring and review. And just as top-level commitment, training, etc., are very much part of the umbrella of reasonable procedures, so is monitoring and review. And you mentioned stress testing. And I think with corporate procedures, anti-fraud procedures, anti-bribery procedures, whatever they might be, the idea of actually stress testing them in a true to life environment is vital. And one of the things we always say at Amicus is the last thing you want to do is actually use your procedures for the first time when an incident, an event is occurring in real life. Much better to actually rehearse that in a safe and secure environment. And of course, Lindsay, as you know, that's one of the things we do at Amicus, where we actually run true to life scenarios very much with that in mind. And of course, for monitoring and review, one can adopt a similar approach and use similar tools. So I think that ongoing review is important. Companies have to learn lessons. And I think clearly the regulators, the prosecutorial authorities will be looking at the way companies have actually learned from what's occurred from past experiences when deciding, if they have to decide, whether a particular company really has reasonable procedures in place. So it's certainly an interesting and indeed challenging landscape. I think it'd be good to get some final thoughts and from some final words. Rasha, let me turn to you. What sort of takeaway message would you give to organisations or representatives of organisations who might be listening to our discussion now?
I think I would say take the opportunity of the Act and the offence to really look into your organization and make a real difference. Focus on training your staff, and there's so many things that you can do in order to demonstrate top management commitment, as well as like your commitment to like countering fraud. For example, organizations can implement tailored programs that address specific roles and relevant fraud risk, interactive workshops that encourage participation and enhance retention. Also, e-learning modules allow for self-paced learning with quizzes to reinforce key concepts. Regular updates and refresher courses keep employees informed about new trends and policies. Many organizations tend to look at training as like a ticking box exercise, a one-off phenomena, which is not really great in terms of like learning and keeping abreast of fraud, given that its evolving nature. Something like real-life case studies illustrate the consequences of fraud, and clear communication of policies ensure accessibility. Whistleblowing is something that is not really just a trendy topic. It's something that has to be taken seriously. So whistleblower training is crucial for encouraging reporting of suspicious activities, and organizations should really make every effort to ensure that it's anonymous and the process is easy and can be followed clearly by employees. Involving senior management in training sessions demonstrate commitment, so it's not just for the employees. And you can include interesting things to make learning a bit fun, like incorporating gamification makes learning more engaging and sends the message straight away. You want staff that learns about fraud, not just staff that attends a one-off session and gets nothing out of it. Finally, I would have to say that testing like your staff knowledge through gathering feedback could help refine the training programs and fostering a culture of integrity and compliance. So really the Act is a great opportunity for organizations to do something different.
Thanks, Brashon. I think within that overview, you've given organisations a really helpful, practical toolkit. By way of final thoughts, Lindsay, you've obviously touched on issues concerning the food industry and academia. Any passing thoughts or pieces of advice you'd give particularly to those sectors?
I think the advice I would give is for people to really read the regulations, because I think there's going to be quite a few people caught out with this, not understanding the changes in it. So I think if it's a very large company, I would presume they have a legal department that would flag it up. And I fear it might be this kind of middle sized companies that are going to be caught out that don't always keep themselves up to date with the regulations. So I think, maybe it needs to be publicised in such a way that people understand that it does affect them.
Yes, I think that sensitisation and awareness is so important. So I think you're absolutely right there. We've had quite a detailed discussion, and I'm grateful to both Rasha and Lindsay for their input and their expert insight. So thank you both for that. I'm sure that if any listeners have any questions or comments or any points they'd like to pick up, that Rasha, Lindsay, and indeed me would be very happy to actually assist and to engage with you. So please feel free to make contact with us if you'd like to discuss any aspect. But finally, the biggest thank you is for the listeners. Thank you so much for bearing with us on what's been quite a technical discussion in many ways. We wish everyone well, and we'll see in due course how implementation of this new corporate offence actually plays out in practice. So once again, thanks so much, and we wish everyone the very best.